Hello everyone, this is Jennifer Schlei, and today I'll be discussing the competence to exercise the right to remain silent. So diving right in here, in order to determine competency, of course, an evaluation needs to be done. So every state permits evaluation if the defendant's competence is in question, and it's important to note that this is not applicable to the time of offense, but rather their present state of mind, and it is also not a determination of guilt. What they're trying to do here is to determine if the defendant understands the legal process in this case regarding the Fifth Amendment right to remain silent. With the competence to proceed, results can't be used in the trial unless they're raising a mental state defense, and that's per Estelle v. Smith, where SCOTUS determined the testimony was unconstitutional because Smith was not informed of their right to remain silent at the pre-trial psych evaluation, and the court had concluded that several amendments were violated during that evaluation, including the Fifth Amendment with their right to remain silent. Melton's best recommendation in these types of situations is to, if possible, avoid including any potentially self-incriminating information from the defendant in the competency evaluation statements. Because again, the evaluation is not to get a confession, but just to determine that present state of competency. So there are some exceptions to the rule, and some pros and cons that go along with that. Per Buchanan in Kentucky, SCOTUS had concluded that this was not in violation of constitutional rights because the defendant raised the mental state defense, and that's why they were evaluated. Some states allow a defendant to refuse answers to certain questions if the evaluation is requested by the defense and if they feel their answers may incriminate them. So could that affect the results of the competency evaluation? Yes. Potential to undermine the defendant's true competency if they aren't answering all the questions in the evaluation or refusing to answer to them. That could pose an issue. According to Melton, this is potential to be problematic as the defense can then call the shot, so to speak, as to how and when the evaluation results are used on mental state rather than just for competency. So just to reiterate, according to SCOTUS via Estelle v. Smith in the Fifth Amendment, the defendant is well within their right to remain silent. If the defendant gives notice of an MSO, yet they refuse to cooperate with a state-retained evaluation rather than their own evaluation that they've retained, that could provide potential to prohibit the defendant from presenting any of their expert testimony, and they would not have the right to avoid questioning by prosecution retained experts either. Also, a less sanctioned method with this scenario is where the prosecutor can inform the jury that the defendant refused the evaluation by the state retained expert, and that of course could reflect to the jury that the defendant is attempting to manipulate the system for their own advantage. So that would not work in their favor, likely. With that being said, per the Fifth Amendment, the prosecution has the option to obtain an MSO evaluation. However, there are restrictions then as to how. So one of the things within the Federal Rule of Criminal Procedure, and that statement regarding that is on the right there. So when the defendant is in an evaluation, their actual evaluation cannot be admitted as evidence, except when it has to do with their mental state condition. Also, if they happen to mention any type of evidence within that evaluation, such as the murder weapon, etc., that cannot be used or admitted as evidence either. However, per SCOTUS, once the MSO is raised, there are no restrictions of the use of the evaluation by the prosecution, and that was per the case of Buchanan v. Penry. So also within the Federal Rule of Criminal Procedure is how investigative leads from a defendant's evaluation are used. So although the prosecution has access to those investigative leads within those evaluations, they are not permitted to use them except in one capacity, and that is where SCOTUS and the case of Canvas v. Shavir had indicated that the Fifth Amendment cannot stop the prosecution from introducing the defendant's psychiatric evidence to rebut any of the psychiatric evidence that was presented by the defense. So in essence, the defense has to mention it first, but this then can in turn allow the prosecution to use any results of that defense requested evaluation for the rebuttal purposes. So the challenge that lies within that are determining what the fruits or the information with the evaluations and determining what truly the fruits are of the defendant's statements, as those are not things that can be used within the federal rules because it could be violating their rights. So according to Melton, they stated that the best method of reducing the potential abuse or misuse by the prosecution or the police within an evaluation process is to restrict the prosecution's access to the results as much as possible. So in one way of doing that is that they suggested that the defendant to retain their own examiner for the evaluation, as that information would then be protected by the Fifth Amendment. However, in a case where they may have an indigent defendant, the counsel can then request a government examiner to perform the evaluation, and in that case, all the results go to all the parties involved, even without a declaration or a request for an MSO. And Melton suggested that the evaluation be done before the MSO is raised for several reasons. First of all, they stated that it's unnecessary because the prosecution is only to receive a summary of the evaluation report, and the information could otherwise tempt them to use that information when they shouldn't. And also, it could be a barrier to the full disclosure from the defendant in their evaluation, because if they're aware of the fact that the evaluation is being done post raising an MSO, those results could be provided again to all the parties involved. And so this could result in them holding back on the evaluation and, basically falsifying that result. So pretrial disclosure evaluation results can be complicated, as I'm sure many of you have surmised thus far. In many states, they have what is called reciprocal discovery, and that's usually incorporated in the state's rules of their criminal procedure. This allows prosecution to discover the reports and the statements of the defense's experts once the defense asks for the information from the prosecution. This can happen even if it's after the fact that the defense decides to raise a defense. And Melton pointed out that the complication there is that this could be construed as a violation of the defendant's Fifth Amendment and also their attorney-client privilege. And how the Fifth Amendment applies to the testimony of the mental state at the time of their offense, an expert might be releasing incriminating information about the defendant in their testimony, and that could of course affect the jury and the other members of the court and how they make their decisions. Now, Melton mentioned some thoughts and approaches to the problem of trial incrimination. Several states provide mandatory bifurcation of the trial process. And with this, the first stage is focusing on the guilt of the defendant, and the second stage, if needed, is focused on the sanity of the defendant, which is, in comparison to most trials, backwards. This approach wouldn't necessarily allow a defendant a fair trial, though, as the relevant testimony may not be presented during the first stage. And of course, that could then lead to a violation of the defendant's Sixth Amendment rights to a fair trial. The unitary trial, which is followed by most states, is a trial process where the issue of the mental condition is to be considered by the prosecution's retained expert testimony. And with this process, this is the only thing that should be considered, and the jury is, of course, cautioned of that fact. Now, of course, this does not fully prevent the jury from using the information in the prosecution expert testimony inappropriately, but if the protections that have been discussed in this chapter of Melton are made available, it's likely not to violate the defendant's Fifth Amendment rights. So with sentencing evaluations, despite a defendant being considered for sentencing, there's still potential for them to self-incriminate. And that would be through the pre-sentence evaluations and post-conviction sentencing. With the reasoning of Estelle v. Smith, capital sentencing should follow procedure according to the MSO evaluation and also the Federal Rule of Criminal Procedure, and that's where the evaluation records are to be sealed until the intent to offer during sentence proceedings. Non-capital sentencing procedure, according to Mitchell v. U.S., given the right to remain silent in sentence proceedings. So if the defendant's story gets told at a sentencing, they lose their right to be silent at that point. And according to McCoon v. Lyle, the right to remain silent resulted in a harsher punishment for them. And that was where they wouldn't list some of their victims, and that in turn basically took some rights away while they were in prison, as far as like commissary and visiting and things of that nature. However, the court did find that to be constitutionally significant. Also, one last thing, juvenile delinquency, commitment, and civil proceedings. The Fifth Amendment still applies within those proceedings, and that's because they are not necessarily considered a criminal trial. Even if commitment is sought out instead of criminal conviction, so say they are looking to put them in a forensic hospital rather than sending them to prison, that particular proceeding is not considered a criminal trial, and so the Fifth still applies. Also, civil proceedings, that entails dependency or child custody evaluations. Attorneys can advise their clients to take the Fifth if their answers could potentially incriminate them. So I chose to discuss the case of Taylor Schabusiness in relation to competency and right to remain silent, which I get to in just a moment. She was charged with the murder and dismemberment of her lover back in February. And this happened where I live in Green Bay, Wisconsin. Just recently, on September 1st, she pled not guilty by reason of mental disease or defect, and that was after she has had 3 competency exams. Additionally, she's going to have another trial on October 3rd to review her mental state, and that's going to determine if she's competent for a murder trial or if she could potentially be sent to a state or forensic hospital, if you will, for an undetermined amount of time. Now, I feel she didn't invoke her right to remain silent because she probably was incompetent, and police went to her home and she started confessing almost immediately, and in a fashion as though it wasn't a problem, potentially. She was still covered in the victim's blood, and this was the next day. There was evidence in her car, evidence in her home, and evidence, of course, in the victim's home. And I'm just very curious to see how this will pan out, I guess, if she is put in a murder trial, and what her rights at that point will or will not be because of everything that's already progressed. Very curious to see how that turns out. If you're interested in learning more about that, there is a recent news clip from our local news about the mental disease or defect plea, and also some court documents from her initial court date on this back in March.